latest report. My name is Kate Krug, and I am the Chief Executive Officer here at the King County Sexual Assault and Resource Center, or KSARC as we like to call it. More of my KSARC team will be joining us in just a moment. But first, I'd like to share a bit about KSARC with you. KSARC is a nonprofit community provider of sexual assault services that include advocacy, therapy, and prevention education. I'll point out that all of our services are available in both English and Spanish, and as an independent organization, all of our services are confidential. To the survivors that are with us today, I want you to know you are not alone, and that support is always available to you. You can start with our 24-hour resource line and reach us at 1-888-99-VOICE. And a little housekeeping here for today. We have a lot to share with you, and there's going to be a lot of questions, or at least we hope there will be. And we'll have time at the end of the presentation for those. Please pop them into the Q&A box as we go along, and we can get to them during our time here. So let me tell you quickly a bit more about what we know. Can you bring up the slides, please? Thanks. So KSARC, we work with about 5,000 survivors and their family members each year. KSARC has been around for almost 50 years, and we specialize in helping survivors of sexual assault. Throughout this time, survivor experience has been informed by our work and actions, and here's what we know based on that experience. We know that most survivors don't report their sexual assault to the criminal justice system. There's a lot of reasons for that, and that's a whole nother webinar. But today, we're talking about survivors who did seek help from the criminal justice system. When they report, survivors are looking for acknowledgement of harm, and accountability from the person who harmed them. In order to recover, they also need meaningful interventions, which can include things like treatment or rehabilitation for the person who assaulted them. Unfortunately, the way victims are treated and the distress victims feel after they report can be an unnecessary and harmful burden. So now I'd like to bring in my colleague, Megan Allen. Megan is our Director of Advocacy Services, and she was KSARC's Legal Advocacy Manager for 2 decades. Navigating Justice is actually a follow-up report to something Megan and her team worked on in 2021. Hi, Megan. Thanks for joining us to share what your team worked on. I know KSARC has shared this data similar to this with our community before. In fact, we have a long history of tracking sexual assault and protection order case data in King County Superior Court. Is that right?
That's right.
So we know from our previous tracking that long waits for justice were happening long before the pandemic arrived. But when COVID hit, it literally shut down courts and other systems. Nothing was moving forward. Can you tell us more about what was happening with our clients and cases as that situation dragged on, and what started us down this path towards the long wait report?
Sure, Kate. Let's talk about what was happening then to start with. We all know that this was a unprecedented time full of uncertainty and disruption. Everyone here, I'm sure, remembers we were scrambling to just manage our day-to-day lives, our jobs, our kids, and just staying healthy. Survivors, though, were also managing all of those things while also having a criminal case pending. So as hearings were being canceled, their fears, of course, were compounding, and defendants were being released much of the time with no victim notice. Advocates were struggling to get answers just to help reassure victims. And things were changing in the courts weekly. Every court we found was handling things differently. There was no consistency from court to court. So the courts felt like they were in chaos. And jails were releasing defendants, not holding anyone, and defendants weren't showing up to court hearings. Bench warrants we found weren't being issued, and instead of detaining defendants, they were increasing the use of electronic home detention, EHD for short, and even for sexual assault crimes, serious sexual assault crimes. At one point, though, we pieced together that the monitoring system, the EHD system, was not actually staffed 100% of the time. We also discovered there wasn't a clear notification system for violations. So you can imagine victim safety concerns were escalating, and they wondered if something did happen, who would help? As the courts were caught up in their own kind of managing their day-to-day challenges, little attention we found was being provided to victims. So victims were feeling hopeless, not only worried about their safety, but they also wondered, would they ever see an end to their legal case? Victims began to lose trust in the system that was supposed to protect them. And we found that even those that were working in the legal system began publicly expressing concerns about the confusion and disruption that had become the norm. So as a community, many of the discussions on COVID's immense impact on the criminal justice system were happening. And even with this focus, victims felt invisible, as these discussions over and over again centered around the impacts on defendants. We saw local leaders talk about strategies to eliminate the backlog of cases and concerns about how the delays impacted defendant rights. Even as we saw reports of domestic violence and sexual assault increase in our community, we heard public leaders focus on dismissal of cases and how to release more defendants. And one can imagine how that would sit with victims. As advocates, we wanted to ensure that victims were also being considered. Before we shift to that report, though, I want to give some quick context about sexual assault. And so we have this graph here that represents national data compiled by RAINN. And first, it identifies how few rapes are reported, only 23%. And as sexual assault cases move through our legal system, the number of rapes that are investigated, prosecuted, and end in conviction become fewer and fewer. Most people probably assume that when rape is reported, it results in charges and a conviction. Unfortunately, the reality is that our system is immensely inadequate at responding to rape, and the attrition of sexual assault cases is the norm, unfortunately, as outlined in this graph that shows, again, national data. So now let's turn to our first report, the long wait. So back in January of 2021, this was just on a single day, we pulled all of our open client cases in King County Superior Court. These victims were CaseArc clients and do not represent all the victims in King County. Just to give some context, we provide community-based advocacy to the majority of sexual assault victims in King County, but there are also system advocates through the city of Seattle. And so while we do provide advocacy for some clients in Seattle who self-refer, this data doesn't represent all victims of sexual assault in our county. So I'll share that also that CaseArc advocates are working with anywhere from 800 to 1,000 victims at any given time. And over the course of a year, we provide services to almost 2,500 victims and families every year for legal advocacy. And the reality is most of these victims that we work with will not see their cases move past the initial report. So when we pulled this data, what we wanted to see was who were the victims we were working with, what had they experienced, and how long had they been forced to wait. What we found was there were 408 victims with open criminal cases where a defendant had been arraigned. Individuals who sexually offend have multiple victims. The average age of these victims was merely 16 years old, and they were primarily female identifying. The average age of the person who abused them, 39 years old. Almost all were male identifying. So our data also highlighted the seriousness of the harm these victims had experienced. What we found was 3/4 of the victims' sexual assault cases were crimes against children. And of those, 38% were Class A felonies. And just to give some more information also, a few examples of Class A felonies for sexual assault are rape of a child in the first and second degree, child molestation in the first degree, rape in the first and second degree. So for perspective also, Class A felonies are the most serious of offenses. And these crimes, these sexual assault crimes that I just named, share the same harm level as murder and human trafficking. These are classified this way because of the long-term and life-altering impact that these offenses have on the victim. And sexual abuse impact for children is not only about the act itself, but also the way in which it can alter a child's natural development. It can damage their understanding of the world and even their sense of themselves. We know that most children are victimized by people known to them. So we're talking about family members, friends, and people in positions responsible for their care. It's also common that people who sexually abuse have multiple victims. So as you saw in the numbers, many of these cases had cases in which there were multiple victims tied to one defendant. And while we often think of sexual violence as an isolated incident, in many cases involving children, it includes grooming and chronic abuse over many years. And so the final piece of information that the long wait gave us was a length of time our victims had been waiting for justice. These victims had been waiting on average of almost 19 months for the resolution to their legal case. So just as a reminder, the average age of the victims in this group were 16 years old, and 3/4 of these charges were crimes against children. These victims were waiting almost 2 years by this point, 2 years from the time the defendant was arraigned. So when you put this all together, we realized we were mostly working with victims who were abused as children, who then were forced to endure years of reliving that abuse in the criminal justice system. And it felt like no end in sight and no guarantee that the person who harmed them would receive any meaningful intervention. So, of course, we wanted to share that information. And I'd like Kate to come back in to share more about how useful that data was.
Sure. Thanks, Megan. So I'll tell folks here that this is prior to my time at KSARC, but our team shared the long wait report with partners, with supporters, and with policymakers. This report helped people better understand what was going on and exactly who was waiting and what happened to them. The unmistakable takeaway was that sexual assault cases had to be a priority as a wider system grappled with the larger issue of court system backlogs. We saw a few changes that sparked the long wait and our advocacy surrounding it. First, we identified and collaborated with system advocates to address the gaps and failures we saw happening with the electronic home detention that Megan mentioned. Remember, she told you that victims were not being notified when the defendant was out of compliance? EHD was also being utilized more and more during the pandemic and for higher risk individuals. By shining a light on this problem, a better victim notification system was developed. Next, we advocated for child forensic interviews to be moved out of the downtown courthouse. That courthouse in downtown Seattle was never child friendly. But during the pandemic, that area became much more dangerous, to the point we saw courthouse employees and staff demonstrating for something to be done. We were meanwhile working with families who expressed a lot of fear and who had experienced harassment as they tried to get their child to an interview. So it was a silver lining that we were able to get those moved to safer locations, including one at the KSARC offices. And finally, in spite of our court system shutdowns and slowdowns, we also knew that unfortunately, new sexual assault cases and victims were pouring in every day to our office. And at this point, we couldn't even tell these victims how long they could expect to wait. New cases on top of backlog cases added an element of even more urgency to this crisis. So the long wait report helped inform policymakers about the impact of this backlog on victims, the need for resources to ensure that courts, prosecutors, and victim services could move cases forward and assist survivors. Now let's bring Megan back to talk about the next chapter. So Megan, now that we have the history and context for what we're talking about today, which is the Navigating Justice report, let's shift into that. We saw a few silver linings when it came from our initial report, like those process improvements to victim notifications and moving the child interviews to safer locations. Those changes are helping survivors now. They might not have happened otherwise. Back when we issued the long wait report, the courts predicted it would take 3 years to clear the backlog cases. So now, fast forward 3 years in time, tell us what your team did.
Yes, you're exactly right, Kate. So based on what we were told, we pulled the data for that same group of 408 survivors this January, 3 years after we first examined their cases for the long wait report. This time we wanted to see how many victims were still waiting for resolution, and of those that had resolved, what outcomes they saw, and it was enlightening. So let's do an overview of this data. On a positive note, 94% of the cases had resolved and only 6 remained unresolved. I'm going to ask Legal Advocate Supervisor Claudia Godina to join me on screen in just a moment, and she's going to share some additional details about the unresolved cases. But first, to start with the resolved victim cases, this chart shows what happened. For 5% of the victims in that group of 408, the defendants in their cases pled guilty as charged. Another 16% of victims' cases went to trial, yet 14% of victims saw their cases dismissed. But the vast majority, 60% of victims, had defendants who pleaded down to a lesser offense. As we know, the vast majority of sexual assault cases don't go to trial. Most cases are resolved as part of a plea, And while victims can provide input on this, ultimately these decisions happen in negotiations between prosecution and defense. So even though sexual assault cases weigh heavily on victim participation and testimony, the truth is that most victims concede to outcomes that don't often reflect the seriousness of the crime. So let's bring Claudia back in now to talk more about the unresolved cases.
Thanks, Megan. As Megan mentioned, 6% of those 408 cases remain unresolved. That breaks them down into two categories. The first one being those that are still waiting for a trial, which is 3% or 13 victims. The second category is the failure to appear category, which is another 3%. Failure to appear, or FTA, means that the defendant has not appeared in court nor communicated with their attorney. In both categories, nearly all defendants are charged with Class A child sex offenses. In January of this year, those cases still pending in the legal system had been languishing on for an average of 1,365 days, nearly 4 years. Then, these are almost all victims of child sexual abuse. Think about the different milestones 4 years makes for a child. In 4 years, a fifth grader would be getting ready to start high school. When we consider the impact on these 408 victims, particularly child victims, we should consider how child victims are bearing the weight of these lengthy case delays. We are creating justice-involved children who are anchored to a system that seldom considers the impact it has on those who engage in the criminal justice system. But now I want to share some different case outcomes that some of our clients had, those who went to trial. 16% of those 408 victims' cases resolved by going to trial. This is fairly rare. The cases that went to trial were among the most difficult, including those involving multiple victims. Nonetheless, when these cases went to trial, juries returned on a guilty verdict 3/4 of the time on these cases. This is a sign that when prosecutors take these cases to trial, juries are overwhelmingly believing victims. This gives us hope. And it's a surprise to see it's not typical to see so many sexual assault cases make it to trial. It makes us optimistic to see that when juries are presented with the opportunity to hear the facts about a sexual assault case, victims are believed. Even in what most would consider a best case outcome, the case goes to trial and returns on a guilty verdict. The toll this process takes on victims and their families is still a lot. Imagine waiting for trial for almost 4 years. You get a call from your advocate once a month, letting you know that not much progress has been made. And then one day, out of the blue, you get a call that you have to set up a defense interview, where you will have to restate the disclosure you made almost 4 years ago in a room full of attorneys. And if you're the victim, especially if you're a child victim, you're trying to recover and heal while trying not to fall behind on your schoolwork. And you're struggling to enjoy normal everyday activities like hanging out with your friends, all while the case is still pending. Now I want to bring Katie Holloman, a CaseArc Legal Advocacy Program Specialist, on screen to tell you about dismissals.
Thanks, Claudia. And as Megan shared earlier, 14% of victims in that group of 408 had their cases dismissed. These were all at different points along the way, but on average, these victims waited 807 days, or 2.25 years, before they were told the person who hurt them will not be held accountable. Again, victims have little voice or control over how a case proceeds. In the cases of the dismissals we saw, these were prosecutorial or judicial decisions, not the decision of victims. This highlights how little the impact on victims plays into these decisions. It also highlights the fact that these defendants never had to be judged or held accountable for their crimes. Victims do not go into this process expecting to have their cases dismissed, and most certainly not after waiting 4 years. Victims tell us they are worn down and they feel the weight of the case on their shoulders. When it's dismissed so abruptly after 4 years, they feel like it's their fault. Let's now talk about plea agreements. These are the most common outcomes of cases. Our legal system is built on the foundation of a jury trial system, but for the majority of cases, it's seldom used. Most cases involve a negotiation that seeks to guarantee a conviction. You may be surprised to know that negotiations don't happen in the courtroom or on the record. They are conversations between defense and the prosecutor, often not feeling transparent to victims. Advocates work hard to ensure that the prosecutors have considered the victim's input, even before negotiating the case. Pleading guilty as charged is a bit of a unicorn in our sexual assault cases. As you saw on the overall chart earlier, that was the outcome in just 5% of our victims' cases. Oftentimes, this means that the case was to go forward to trial, that the prosecutor could add additional charges or counts. So I'm asking Megan to come back in, but I'll start by sharing that of the cases that resolved in a plea agreement, 1/3 of our victims' cases pled to a lesser felony sex offense. For example, rape of a child pleading guilty to assault 3 with sexual motivation. That change means the charge goes from a Class A felony down to a Class C felony. Megan, do you want to talk about the other 2/3 of those cases that pled down?
Yeah, so as Katie mentioned, the majority of cases pled to a lesser charge. So let's talk about that remaining 2/3 of victim cases that pled. And of this group, 1/3 of the victims saw their offenders plead from a sex offense to a non-sex offense. Another third of them saw their offenders plead from a felony to a misdemeanor. But even more sobering is that 21% of the cases pled from a felony sex offense, or many times multiple felony sex offenses, down to no sex offenses and a misdemeanor. In many of the cases, this plea down was also to something called assault in the 4th degree with sexual motivation, which is a misdemeanor non-sex offense. It has sexual motivation in its name or title only. It's important to consider that victims tell us that words matter. And when cases are pled to outcomes that deviate so far from the crime itself, that lack that accountable language, it feels minimizing and dismissive, as if the harm they experienced is not that big a deal. Victims tell us that this process of negotiating cases often makes them feel like they are the problem, not the offender. So what does this mean for victims and for us as a community? For the most part, it means no criminal SAPO, no registration for the offender, and no reporting or supervision. These are important pieces that get lost, including the opportunity for meaningful interventions such as treatment. We know the courage it takes for victims to seek help, let alone report. And we know that victims that do choose to come forward many times do so in that hope that taking the risk, their personal risk, will prevent this from happening to others, and the offender will get the help that they need. In reality, victims have little control over the punishment the system hands out. The power of our system lies in the hands of prosecutors, defense attorneys, and judges. So victims want people to stand with them, to recognize that a wrong has been done, and to have the community join in placing that responsibility on the offender where it belongs. Victims tell us that when the system fails to take their reports seriously or to hold offenders accountable, they feel unheard and dismissed. And these feelings are valid. Victims endure years of continuances. Defense tactics of delay, victim blaming, and intimidation are very real to them, and only to see an outcome that feels like a slap on the wrist. When victims of rapes see their sexual assaults watered down to a misdemeanor with no protection, no supervision or treatment, of course they're discouraged. So to help illustrate this experience, I wanted to share the words of one survivor we worked with. And so with her permission, I share part of her victim impact statement that was given at sentencing. And this was after several years of enduring multiple legal steps, long delays, and being grilled by defense. Not only are you going to hear her speak to the defendant for the harm he caused, you're also going to hear her frustration with the system and the process. So she says, "This entire process has only been enforced the fact that I am not a victim, but a villain for getting close to you, for trusting you, for being raped by you. I've been reminded over and over to consider the severity of the crime, as if I could not already feel it in my bones. Within the justice system, I've been made to feel that I was wrong, instead of assured of the simple fact that I was wronged. I think you'll agree that these are really powerful words.
Thank you so much, Megan, Katie, and Claudia. Your work with survivors is incredible and vital. And I'm jumping back in here just to wrap things up. We're going to take your questions. I really encourage you to pop them into the Q&A box. And while you're doing that, I'll just say we want to continue the important changes for survivors. And that began with our initial long wait report. With all that we know that happened in those 408 victim cases, we asked system partners to collaborate with us to better listen and respond to victims and advocates, and to acknowledge the impact the experience of sexual assault and the process of the case has on a survivor. We know that victims come forward to report because they want some accountability for what happened to them, not simple vengeance, but meaningful intervention that can include treatment and rehabilitation. It would really help change outcomes and experiences if we had more data like this and a more complete picture of outcomes, especially as related to victims from marginalized communities. We are, as a society, and rightly so, looking at whether the criminal justice system is treating defendants equitably. But at the same time, we must continue to make sure that victims from those same marginalized communities are not being sidelined. And I'd be remiss if I didn't talk about resources to ensure survivors' needs are met, whether they report or not. Our long wait data helped policymakers understand what was happening in our courts, and it provided fuel to allocate resources and make other policy decisions. Our work is more important than ever, and working together with system partners, we can make the case for strengthening public resources for prosecutors, courts, and victim services. So with that, why don't we go ahead and take our first question. Let me open up the Q&A. So our first question, do changes in charges affect a victim's ability to go through the civil system for protection orders? Megan, I'm going to turn to you for that one.
No, those do not directly affect a victim's ability to go through a civil system, but in many ways, because of the length of time that a criminal legal case can take, it can delay, obviously, options for people to go forward in civil actions. But victims can simultaneously be working with advocates to pursue a civil protection order and ensure that some of those other needs outside of the criminal justice system can be met. There is not a direct impact, but the length of a criminal case and the changes, the plea downs and the outcomes can often discourage victims from wanting to pursue other options.
So what do you tell victims when the outcome is something other than guilty to the original charges?
So what we really try to ensure that victims understand that the criminal legal system ultimately doesn't define what happened to them. They know their truth, they know what happened, and it does not take away from their experience. And it does not define that the legal system cannot tell them that it didn't matter and it wasn't important. And so we really work to walk with them side by side, help translate that system, and help them understand while the system is not perfect, that we support them, we believe them, and that the legal system and the outcome of the criminal case is not a definition of what happened to them.
Yeah, I have a question for myself in there. And I already know the answer, but I'd like to hear, how important is it that we just say the words, "We believe you"?
I would say that's probably at the center of what we do, and most important, that victims need to feel acknowledged. They need to feel heard. They need to know that what happened to them mattered. And while those are just three kind of simple words, the reality is the power of those words is often just a relief to victims and a willingness to continue to engage in even services, not just the legal system, but to feel that they can kind of remove that burden of shame that they've often been carrying that doesn't belong to them.
Mm, thank you. So, Megan, are there restorative justices outside of the criminal legal system, like options available to survivors in King County?
In King County, we have options in regard to seeking out ways that victims can protect themselves through civil protection orders, ways in which that victims can work with their advocates to address needs that they might have within the school system, to make sure that they get the supports and the community is wrapping around and responding to how to ensure that victims can overcome what happened to them, rebuild their lives, and to heal from this process.
Thank you. What resources are needed to support victims, and what kind of partnership do you need from system partners? Oh, that's an excellent question. I'm happy to take this one on myself. Please let me know if you have anything to add, Megan. So when CASARC released the long wait report, we knew that resources for courts, prosecutors, and other components would need to be addressed to help with the backlog and given the ongoing pandemic. We actually advocated to the state and county officials for more resources for systems and called on the city and county electeds to help advocate for state funding for victim services in last year's budget. We need all of the pieces in the system to work. Services for victims and the system given enough resources to function as it should. That's going to be even harder going forward because we just heard that federal resources that are called VOCA that support victim services like those that we provide, victim compensation, training, and other resources that prosecutors will need are being significantly cut this next year. That means less federal money coming to Washington State for all of these things. So yes, we are concerned about that, but please stay tuned on more info on that. Well, this has actually been a wonderful way to have a midweek webinar and how to end Sexual Assault Awareness Month. Megan, once again, I just want to say thank you to your team and thank you to everyone who's joined us on the call today to learn more about the long wait report and our Navigating Justice update. And in case you missed it, you can find the report on our website. You can visit us at casarc.org/resources. It's right at the top of the page. That's all of the time that we have for today. I saw there were a few more questions in the chat, and we hope maybe we can address them in the email follow-up, but I hope you have a great rest of your day, and thank you again from everyone here at CASARC.